Thanks again, Sasha and Matt. And also thanks to the wider team at Aquamore, for having me here today. Special mention to Delphi Georges of my team for assisting with the presentation as well. I guess for everyone's benefit, especially those who I haven't met, I've worked in banking and finance for about 25 years, both as a lawyer in private practice, as in-house finance counsel, with one of the four majors in credit risk and loan markets. So kind of with that experience, what I can offer and hope to convey to those who are watching is the perspective and insight from a borrower or director's perspectives, from a creditor, and obviously the legal perspective. Now, as it's always hard to observe Chatham House rules online, I'll do the obligatory notice, as my Office of General Counsel requests, is to read the disclaimer of kind of what I'm communicating today. So as you can see on screen, the information provided in this presentation is for general information purposes only and doesn't constitute legal advice. While every effort has been made to ensure the accuracy of the content, it should not be relied upon as a substitute for legal advice. No solicitor-client relationship is created by attending the presentation or reviewing these materials. For advice specific to your circumstances, please consult an Australian legal practitioner. And in New South Wales, Queensland, SA and Victoria, liability limited by a scheme approved under the professional standards legislation. So that's as lawyer-like as I'm going to get into today.
You've lifted the bar, Chris. What were you going to say, Matt?
That's the most lawyer I've ever heard you talk.
I know. And with water well in hand.
Absolutely.
So, as the disclaimer says, this is really general in nature only, and it's certainly I'm providing legal guidance, and but certainly not credit risk advice, as one of my old GMs used to say. He knows enough to be dangerous, and that's certainly the case in credit risk. So as Sasha mentioned, I'll be covering off on the legal side of commercial benefit, common misconceptions of cross-stream guarantees, upstream guarantees given by directors, third parties, or related bodies, corporate or related entities. And for those of you that want to delve into that, the broader definition of what a related entity means under Corporations Act, I'll leave that for your Googling delight. I'll give you some examples of commercial purpose and also what is not a commercial purpose. Before we kind of get onto the main topic, I always like to remind clients and people of the broader corporate concepts of directors' duties, the behaviours of good faith, and acting in the best interests of shareholders or unit holders under whatever structure that you have in front of you or is presented. And these concepts form part of the wider discussion of commercial benefit. Sorry, I should actually hit onto the slides as well. So there we go. So directors' duties, just as a glance, directors have to fulfill both statutory and common law duties, amongst other requirements. So they've got to act with care, diligence, and skill. They've got to act in good faith in the best interests of the company or as a trustee of a trust. Act for a proper purpose and avoid conflicts of interest. I guess the transactions contemplated and undertaken by directors must comply with these duties as well as be documented well.
Yeah, I think that's a really good point, the director's duties, because obviously it's non-coded in nature, everything that we do, for example. Directors have to act in the best interests of the company in regards to borrowing the money. So there is, to an extent, as a lender, there is a bit of safe harbour in that respect, that they are acting in the best interest of the company, which could potentially make it a commercial transaction. We also cover that off with the business purpose declaration as well, but you'll probably know more about it than I do, that there are occasions where the business purpose declaration is not enough in isolation. That's probably a fair comment, isn't it?
Yeah, and I think that's where, I think you touched on it earlier, Matt, where, even looking at independent legal advice and independent financial advice, is really important, and another touch point on kind of getting the efficacy of why guarantors are coming into the structure or providing guarantees. So, when again looking at it from a credit perspective, you want different touch points or different avenues where you can really look and enforce of commercial benefit. Why is the borrower getting into the transaction? Why are the guarantors providing that type of credit support into the transaction as well? So to have your stat decks on those issues, to get the advice that's provided by lawyers or accountants, is quite essential for commercial benefit and for the credit risk review of getting clear understanding of what commercial benefit is in for the corporate or the trustee or the individual.
Chris, can I just pause for a moment? Because I'm just looking at this with the broker's hat, and this seems quite overwhelming in terms of actually determining whether the director is acting with care, faith, etc., etc. So, Matt, how does Aquamore or how do lenders support brokers to determine this, or is this something the broker needs to determine independently with the client?
Look, I mean, it's a really good question. We touched on earlier that we accredit finance brokers in order to do transactions with us. That part, obviously, we look at the broker's experience and who their aggregator is and all that sort of stuff. And that's kind of a sniff test for us, in that the broker knows who they're dealing with on the front end. They're aware of who their potential client is, who the potential borrower is. There's not a whole heap of emphasis put on the broker in regards to smelling out the director's duties and is the director good enough to perform these kind of duties. But it's probably best explained via way of example, in that there are a number of transactions that are coded in nature, i.e. the NCCP Act will apply. The brokers watching this call have probably seen this a few times, where a company was established 2 days ago, and that company comes to a lender to try and borrow money for an ambiguous purpose. Let's call it, say, an incomplete build. There's a small house that's 50% done, and the applicants have run out of money, and all of a sudden there's a new company that was created 2 days ago in order to borrow the money to complete the build. It's a circumstance like that you would look at it, and you can obviously run credit checks on individuals after they've signed the privacy and stuff like that. That will show how many companies are directors of, if and when they've been appointed as company directors, and you can use that to determine their experience as company directors. And again, we see a lot of these transactions on a daily basis, where there was a company created a day ago or 2 days ago, innocent enough or not, whether it's they're trying to circumvent NCCP or whatever the story is. You can use that as an example to say, well, they don't appear to have had too much experience as a director or too much experience in this field. And it's transactions like that you would probably look at it and say, are they acting in the best interest of the company, and can this potentially be set aside? Again, I'm looking at this from a lender and a credit risk perspective, and we work closely with the brokers to identify the risks. It's not them against us or you against us, and we're not trying to pick holes in submissions or make people feel bad and all the rest of it. It is simply just, we are working together to try and get the right outcome, and we can identify things and say, look, we have got concerns with this transaction, and here's why, and work with people to try and get the right outcome.
So I guess in that respect, it's really to make sure that it stacks up. So if it feels out, that's a red flag. So as you were saying, there are multiple trigger points of why it might feel out. So I guess it's just that investment from the broker to make sure that there is adequate due diligence done, but also just that common sense that's applied to make sure that the funding requirements, and particularly the use and exit plan, actually stack up. Would that be fair?
Absolutely. I mean, we do ask a pre-qualifying question in almost all of our interactions with brokers up front, and it's, what does the client do? You'd be surprised about how many times the response is, I'm not really sure. And it's that pre-qualifying question that really gets the wheels thinking. It is very difficult to find transactions, especially in this market, and you know, I don't think I could ever be a broker. I think it's a really, really difficult job. You know, and we've got a hell of a lot of respect for the people that refer us deals. We know how difficult it is out there. But that pre-qualifying question of what does your client actually do? If the answer is I don't know, or I'm not really sure, or they might be PAYG or whatever it is, then you've already started to drift towards this area where it might not actually be a commercially minded transaction. And whereas, you know, yeah, the client is involved in this and they've been doing it for 20 years, and here's their website and here's the shop front, and you know, I've been to see the client's warehouse and I've actually seen their operation and all that sort of stuff, then you're 100% on the right track. So just little things like that can really help determine what's what.
So I guess it's really that legitimization piece. But Chris, we're hijacking your presentation.
No, no, no.
I'll let
No,
you,
it's meant to
I'll
be
let you
interactive. It's
continue.
much easier. But you know, Matt's absolutely right. You know, directors and companies can't, you know, run away from their obligations to ASIC, and certainly their obligations under Corporations Act. So as Matt says, you know, the broker has to know his or her own client. You know, the onus really does fall on the director, but you know, if you're presenting a credit to a non-bank lender, or you know, the likes of Aquamore, you know, the easier credits is when you know your client backward to front, and you know, being an ex-banker as well, it's clear when you come up to credit risk of how well you know your client or you don't know your client. So I think that's, you know, again, coming back to be most important, especially in an unregulated environment where the reason for that is speed to market, as opposed to we're not going to adhere to Corporations Act or the usual rules that would apply in general commerce or out of the marketplace. So I think that, you know, we're trying to dispel that from the non-bank space and the unregulated space to say, hey, everything is ethical as it should be, and ethical. So, you know, please present and please understand what's in front of you, rather than putting everything and anything up and then getting you know, an adverse review at the end of the day for your client. So yeah, sorry. So anyway, going, you know, with that all in mind, you know, I guess the main concept of what we're talking about is, you know, what is commercial benefit? So, you know, really it's about a gain or advantage, usually financial, that a business or a company receives, you know, as a result of its activities or decisions.
Sorry, Chris, perhaps move to the next slide.
Oh, sorry. There we go. I think I've got it. Yep. No, there we go. Sorry. On the tech ball. Thank you kindly. So, you know, there's generally a positive outcome, of course, within commerce. You know, you want profits derived from a commercial transaction. So, you know, for the lawyers in the room or the non-lawyers, delving into Section 229 of the Corps Act, that section deals broadly on financial benefit. Now, it could include non-monetary advantages and informal arrangements. Really, what the courts look at and what ASIC looks at is focus on economic and commercial substance. You know, that's, you know, what Matt was saying before. Why are you doing this? What's the benefit to everyone within the structure?
So Chris, can I interject there? So in a nutshell, in layman's term, is this just making sure that there's essentially not a loophole, that people aren't getting funding based on some random loophole that they're constructing to then enable access to funding which otherwise would not necessarily be available to them?
Well, inadvertently, yes. It's not so much creating the loophole, but creating, you know, the real reason behind what they're doing and why they're asking to borrow money from lenders. So, so in that respect, it really comes down to, you know, what type of the transaction is and all the good credit and legal reasoning behind that.
Great, thank you.
No worries. So I guess what I want to convey with regard to and with respect to guarantors in a lending structure, what we'd normally see, and of course it forms part of the conditions precedent, and certainly what Aquamore requires as well, are extracts of minutes of meetings or verification certificates or declarations where the borrower and guarantors confirm the commercial benefit of the transaction. Now, obviously, it's easy for a borrower to confer that, and also a parent company if there's a parent company with different subsidiaries. That parent company typically, gains a benefit because the loan is made to the subsidiary. It'll help it to be successful, and assuming that it is, it'll benefit that parent.
Chris, perhaps go to the next slide.
Yeah, there we go. Thank you. Got it. Thank you kindly.
I'm a mind reader.
Oh, no, it's good. It's like, hang on, what's he talking about? Anyway, we'll get there. So guarantees can generally involve upstream guarantees, cross-stream guarantees, or directors' guarantees. Obviously, upstream guarantees are from subsidiaries for the parent co or the whole co's debt. Now, if we're talking about acquisitions, just be careful of whitewash requirements, and that's probably a whole new segment or a whole new podcast to touch on. Cross-stream guarantees, again, when other subsidiaries or obligors within a group guarantee each other's debt or each other's security positions. And then obviously director or personal guarantees provided by directors.
Chris, I might just stop you pardon me, on that note. Can you maybe just go into those in a tiny little bit more detail, just for people who aren't familiar with the language, and particularly terms like whitewash that may not be used in a day-to-day context?
Sure. So again, coming back to Corps Act, whitewash provisions are required where a target company is acquired by another company and provides securities or guarantees for the performance of that loan to the parent company. So there's a certain procedure to, again, take care of and ensure that shareholders of that target company aren't being prejudiced. So that's probably in its broadest sense. There's a lot more that goes on behind the scenes, and ASIC requirements on documentation and process and procedure, and taking 14 and 28 days to get through that procedure. But that's again quite an important view on how companies are acquired, and material benefit requirements on acquisitions. So it does involve a guarantee, but I don't think we see too much of that in the non-bank space. It's certainly there to think about, but in terms of guarantees, how we see normal structures and normal borrowing structures, 95% of the time it's quite vanilla in that respect.
Okay, great. Thank you.
That's all right. So, what are the risks if you run foul of commercial benefit considerations? I guess as a borrower, you compromise the bankability of your structure and the credit risk of the structure. Remembering, the extract of minutes and the verification certs are CPs to funding. So whilst you might meet other requirements and you can't meet those requirements, you won't reach that full condition precedent fulfillment, and you won't get to draw down. So also, as a lender, you can also be vulnerable to challenges after the fact with certain guarantors within the structure that you just lent to, having no commercial benefit. And again, a guarantee, as Matt was saying, and he's absolutely right, a guarantee without any benefit might be unenforceable or even voidable in insolvency, especially when the lender needs it at its most.
Yeah, 100%. I think third-party guarantors are very prevalent for that sort of stuff. I remember when I was a banker, third-party guarantors they didn't really put too much interest in them. If you're getting a guarantee from a third party and it was improving your credit position as a banker, as a lender, then our encouragement was to to take the guarantee and ask questions later sort of thing. That was what, 2015, 2016. So, you're talking 10 years ago now in the sort of SME space, which is probably a lot different now. That commercial benefit piece is really important for third-party guarantors in respect of what it is that they're getting from the transaction. One of the best examples is probably mum and dad, right? Pledging the house for the son's new business. Back in the day, that would have been a no-brainer, unencumbered house, mum and dad are retired, paid off, whatever it is. But as you're aware, Chris, clients will say anything when their back's against the wall, and they need to get out of these debt obligations, and that's one of the key things that we've seen is third-party guarantors will say, well, we didn't derive anything out of this. Yes, we were being nice at the time, but my son is X, Y, and Z now. I won't use the superlatives, but he's it is what it is. We're no longer friends. We're no longer getting on, and we want to retract that guarantee. And we have seen that before, right?
Oh, absolutely. And again, and that's why, the independent legal advice is really important. Not only to the borrower or the guarantor, but certainly to the lender as well. So, why are they signing these documents? What do they actually mean? And for a third party or a third party lawyer to come in and say, independently as it is, these are your liabilities, these are your rights. If you're providing this security, and sometimes you have to look into the guarantee as well. The guarantee documents sometimes allow powers of attorney without guarantors knowing that you've got a right to there's a right to do that. And could the family house be up for sale? Absolutely, if it comes to it. So there's always a lot of caution in signing legal documents and what they mean. And I know a lot of borrowers and a lot of clients are like, oh gosh, this is a whole nother process. This will take another 1 or 2 hours out of my day. There are far bigger issues when it comes down to your own family house or your assets than taking 2 or 3 hours out to actually understand the transaction itself. So yeah, absolutely.
Okay.
And just to, I guess, continue on with that, both small, medium, large, and public companies have to comply as well with all the commercial benefit rules, rules under Chapter 2E of the Corps Act. And these really are to flesh out and provide transparency and, again, at that level, member approval, etc. And same again, consequences of non-compliance. Transactions can be voidable. There are different consequences for companies and individuals, and also penalties that go against it. So it's just not a matter of you won't be able to get or be lent the money or be provided with the debt. There are other consequences for you as a director or as a guarantor, being caught potentially within a larger case before the courts. I guess, as we all want kind of, modern day kind of cases and understanding what's gone in front of ASIC or in case law. And I might turn to the next slide. That'll help. Thanks, Sasha. So there was a case where ASIC alleged that a financier engaged in unconscionable conduct, which was designed to avoid the NCC. So the financier provided loans to companies or to a company to avoid that operation. And also in circumstances where the financier knew or ought to have known that the loan was for domestic, personal, or household uses. The loan was structured where the company was named as a borrower, and one or more of individuals, typically guarantors, or the registered proprietor of securities was named as a guarantor, where the companies retained no benefit from the transaction, had no genuine interest in the loan. the company had been established for the purpose of obtaining a loan only days prior to the loan settlement, and really the company had no or minimal assets or trading activities. So in this kind of case, and it was, you know, within the last 6 months, ASIC really bore down on not only the directors but the lender itself for not going and you know, deep diving, or not even deep diving, but looking into the real credit issues and reasoning behind the structure and the lend. So, you know, ASIC's, I guess, key takeaways were, you know, lenders were to look at structuring loans through corporate entity and corporate entities by, you know, not bypassing NCC, and really understanding the true purpose or the true reasoning behind the loan. And ASIC will scrutinise the actual use of the funds and just not the, I guess, the legal structures. You know, loans to companies with no assets, minimum trading history, things like that, you know, especially being established days before the borrowing or the lend, is obviously extremely high risk. And again, you know, non-bank lenders and lenders, you know, have to verify the borrower's genuine commercial need and obviously at the end of the day, the capacity to repay and the security structures around them.
Yeah, I think that fourth point, the company said minimal to no assets and no trading activities, is really important. Obviously, we ordinarily take a GSA, general security agreement, over the borrower when you know, when proceeding with a transaction, and the whole point in a GSA, as you're aware, is to put a fixed and floating charge over the company's assets, both tangible and intangible, to strengthen the application. And we've had brokers reach out and say, "Oh, can you waive the GSA?" And I think that for us shows a real understanding of the transaction, in that there are assets in there that they might want to leave alone, or that may or may not strengthen the transaction. But I think the case you're referring to with ASIC there was that there was no assets because the company was only established a couple of days ago. There was no trading activity. Again, they wouldn't be aware of what the ANZIC code was for the client. So those are all sort of really important points. If there's no assets and no trading activity, then is it truly a commercial purpose, right?
And at the end of the day, you know, from a credit risk review, you're looking at, you know, guarantors providing a guarantee. You take the A&L out of them and really look at, you know, what's behind the asset. Can you get to the asset? It's meant to be, you know, an asset of substance. If suddenly, you know, 2 days earlier something was created with zero capital or zero asset, you know, that's going to be a red flag in itself.
Yeah.
So maybe if we just use that terminology, I know that we've sort of talked about that in general terms, but, you know, just off the cuff, if we could summarize like some common red flags, and I know that they've sort of been peppered through today, and particularly with the no assets. So, and particularly both of you have been in the game in your respective fields for some time. As a broker, what would be sort of those immediate red flags?
Yeah, again, company set up a couple of days ago. Clients applied for finance through all of the majors and has been turned down for one reason or another. I don't like using the word sketchy, but sketchy clients that you can't really get an answer out of. You know, you ask them a couple of questions and they're very they want to withhold a bit of information, and you can't really get to the root cause of what it is they're doing or what they're trying to do and what their end goal is. I mean, I'm not a broker, as I said, but understanding the client's sort of end goal and keeping their interests at heart. Obviously, you've got best interest duty, which is not really applicable for this sort of webinar, but asking them questions that you can't get answers to, and if you don't really understand the transaction, then they're red flags in themselves. That's my opinion, yeah.
Chris, do you have anything to add?
Yeah, no, listen, I think we've covered it, and you know, just on the slide, just to recap, you've got to look at, as Matt was saying, how readily information is available from the borrower. Certainly if you're in need of finance, you're going to have everything behind you at at the touch of a button to present to the lender to say, hey, I'm coming here. This is what I can offer. You may have been turned away from other financiers or non-banks or other lenders, but there are reasons for that. But from what I'm presenting to you, it's definitely all above board. I've thought about why I'm doing it, how I'm doing it, and with the right credit support and the right security to make, I guess, the financiers, or in this instance, Aquamore's job a lot easier to get through credit and to get to that funding point. So
okay, great, thank you. I might actually throw to a question that we've had from Joff. How do the asset separation goals of a business, pardon me, e.g. purchase a commercial property for use by the company under a rental agreement, so the property is not directly exposed to the risks of the trading company? I'm just going to also just put that in the chat function.
Yeah, how do the asset separation goals of a company? I'm not overly sure what the question is, but I kind of get the basics of it. So what we would, yeah, asset separation is something that does happen. Again, if it can be properly explained as to why. In this particular instance, it looks as if they're pledging the commercial property as collateral, and there's rental income coming from that. Given that the property is commercial in nature, the NCCP Act automatically wouldn't apply, so that's something that can be used as safe harbour in that instance. Using asset separation techniques in that particular instance is not something, again, with the right explanation, I don't really see it being too much of an issue. There may be other assets in personal names or other companies within the structure that may have debt against them. They may have negative pledge covenants against them, in that other lenders are not allowed to register fixed and floating charges behind them, or second mortgages, or it may impact upon interest cover ratios in different parts of the business. If all of that can be commercially explained, then you've done your due diligence, you've met the reasonable inquiries test, and as a lender, I'd be comfortable enough to proceed on that basis if everything stacks up.
Okay, great. Thank you, Matt. And I've also just flowed through another question that's come through from Elle. There are no issues with the client setting up a one-day trust to purchase commercial land, is there?
That's a bit of a harder one. On you go, Chris.
Yeah, well, listen, you can structure, and obviously structuring through trusts, can be beneficial, especially with discretionary trusts, etc. Again, it goes to what we've been saying, what Matt's been saying. What's the benefit of setting up the trust? What is the right credit support behind the trust? Is the trust the commercial vehicle or the actual SPV vehicle to hold the assets? So I think you've got to look at the structure in its entirety, and understand why certain trusts have suddenly arisen. Could be the last couple of minutes they've got round to their accountant or whoever it is to say, hey, listen, this is the best structure for the family or for the business. Again, you've got to look at it at the broader credit risk context and legal context.
Okay, great. Thank you. And we've had an interesting question come in from Matthew. If a borrower is a company with a trading history and uses the funds to enter into a commercial loan with the director, what are the key questions to ask?
Yeah, it's interesting. So that will fall under Division 7 rules, I believe, Chris. That sounds about right, doesn't it? Division 7, if the company's lending money to the director.
Yeah, on Division 7A, so the borrower is a company trading history.
I think the key considerations would more be from a tax perspective. It looks like they're sort of trying to move assets around in the company. If they've got excess cash, they're maybe trying to get use of that for personal use. I guess that would more be a taxation kind of issue. But again, I would just lean heavily on what the purpose of funds is really for. ordinarily, directors got a lot of money tied up in the company and they want to go and buy a Ferrari or a boat or have a nice holiday or something like that. That's a lot of the times you see Division 7 loans used for that sort of thing. And if you're willing to look the other way and disguise it in the right manner, then, is a trip to Europe, can that be tax deductible and all the rest of it? I guess that's a question for the client's accountant or tax professional, right?
Yeah, and I'd also kind of look at, subordination issues on, directors' loans, or, if you're then looking for financing, how does that sit with all the, what would we would call leakages from balance sheet. So again, you've got to really nut down the flow and the reasons, as Matt was saying, the reasons why things have been done.
Thank you. We'll go to one last question before we give Chris his mic back for his deck. We've got a question from Michael. What are the benefits/protections of dealing with a lender that is covered by an AFSL or is a CRA of an AFSL? How do we confirm their credentials?
Yeah, it's a good question. I guess it's a matter of legitimacy more than anything else. Obviously, there's a lot of hoops and hurdles to jump through in respect of obtaining an AFSL and not only getting it, but maintaining it as well and passing your audits. And you have to have a responsible manager who, they're very stringent on the stuff that they ask for. And, our responsible managers never missed a meeting. And, I guess, yes, I guess it's a form of legitimacy in respect of what you need to do to get one of them. Confirming credentials is a case that every FSL has a unique identifier, which is ordinarily a 6-digit number. That can be cross-referenced with ASIC directly, and you can even just type it into Google and just say who owns AFSL and the number. And if you're dealing with a lender that's got nothing to hide, then just ask them the question, what's your FSL number and who do you do this? And can you give me a bit of comfort around X, Y, and Z? And kind of ties into what I said earlier about sketchy clients. If they've got something to hide or they're not looking to reveal information, then you might have a red flag, and that probably applies to lenders as well, which is a really prudent question given that there's a lot of lenders popping up all over the place now, and there's an abundance of money coming in with interest rates looking like they're going to drop today. So